Affairs will come to order. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton, Hughes.
Lay out House Bill 766 by Representative Cortez, sponsored by the Dean of the Senate, and the chair recognizes the Dean to explain House Bill 766.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 766 relates to the ballot application requirements for the election of a precinct chair. This is a very simple bill. It simply would require precinct chair applicants to include their email addresses, phone numbers, or both on their applications, and ensure that contact information would remain confidential and not considered public information. That's all it does.
Thank you, Dean. We'll open public testimony on House Bill 766. No one has registered to testify on, for, or against. I will ask, is anyone present wishing to testify on, for, or against House Bill 766? Seeing and hearing none, public testimony is closed. Bills left pending at this time.
Thank you.
lay out House Bill 677 by Representative De Ayala, and the chair recognizes Senator Birdwell to explain the bill on behalf of its sponsor, Senator Bettencourt.
Thank you, Mr. Chairman. Members, HB 677 is the companion to SB 2819, which this committee voted out unanimously on April 28th. HB 677 prohibits county election administrators from holding an office or position appointed by an elected official while serving as an election administrator. So with that, Mr. Chairman, any questions? I'm done.
Thank you, Senator Birdwell. As we understand the law, there are already limitations on what an elections administrator could do, and this would add being appointed to a political office. Is that how you understand the bill?
Yes, sir.
Thank you. We'll open public testimony. Pardon me. No one has registered to testify on, for, or against House Bill 677, so we'll ask, is there anyone present wishing to testify on, for, or against House Bill 677? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. The chair now lays out House Bill 3133, Representative Bojani's bill, sponsored by Senator Huffman, and the chair recognizes our colleague, Senator Birdwell, to explain the measure.
Thank you, Mr. Chairman. Members, explicit deep fake material is a growing concern on social media platforms, often used to harass or exploit individuals without their consent. Clearer reporting and investigation processes are essential to ensure timely action is taken to protect individuals from the harmful impacts of this technology. HB 3133 adds explicit deepfake material to the list of content for which social media platforms must maintain an easily accessible complaint system. The bill requires social media platforms to do the following: remove content reported as explicit deepfake material, confirm receipt of a complaint within 48 hours, conduct an investigation into the complaint, and provide a written update on the status of the complaint not later than 7 days after it's submitted. Lastly, the bill outlines investigative procedures for platforms that receive complaints. Some of you may know the federal government recently passed the first major law addressing AI-induced harm, the Take It Down Act. This bipartisan legislation was passed the Senate as is expected to be signed by President Trump, criminalizes non-consensual deepfake pornography, and requires platforms to remove such content within 48 hours of receiving notice. And in light of this development, on Senator Huffman's behalf, she says she plans to leave this bill pending to closely review both pieces of legislation and ensure there are no conflicting processes for the removal of this harmful material. And I do have a question of a resource witness, or if there's a social media smart person.
Oh, thank you, Senator Birdwell. We do not have a resource witness on the bill right now, but we can get information before the bill needs to be voted on. Please go ahead.
Because I've got to step out here in a little bit, Mr. Chairman. May I pose the question to you for the committee to take as a question for the record?
Please do.
So that it can be answered even if I'm not here, and then I can see what the answer is. I certainly support the bill, but on page 3, line 5, it says investigation of explicit deepfake material. A social media platform that receives notice of explicit deepfake material on the social media platform shall conduct an investigation to determine whether the content reported by the user is explicit deepfake material. The way that's worded, it makes the presumption that all reports of something being a deep fake are in fact true. How does a social media company know that the first posting wasn't fake, but you could have somebody that there's video that is real, and then the person that reports it as a deep fake, it's not actually, because I'm not social media, how they do this, what the algorithms. But what if the person that reports it as a deep fake is actually not the truthful person? How does the social media company know that? I would assume there's something in how the material's placed online But remember what Solomon says in Proverbs, he who speaks first seems wisest, so the second comes and examines him. That doesn't mean the second's always right. It means you got to hear both sides of the story. So I just need to know how does a social media company know first posting or complaint is the accurate, and I don't know how the
Right.
algorithms, IP addresses, I have no idea how they do that, but because I could have something that's actually posted that's real, come and make the complaint, and now they take it off because I've made the complaint claiming it's a deep fake, but in fact it's not.
Makes sense.
So how does the company know how to do that? Is that even a possibility? It's not much of a probability, but is it a possibility in the social media world? So that would be my question to
That makes sense.
try to figure out the answer to.
We need to know that. We've learned, we've read, and we've all read about AI and about its growth, and
Right.
and we've at least heard it generalized that we are getting close to the point where AI will be so good that based on current technology, it will be difficult or impossible to tell the genuine article from
Right.
the deep fake. So to your point, we need to know that.
Right. Thank you, Mr. Chairman. I appreciate it.
Thank you, Representative. Thank you, Senator. We had previously asked if anyone present wishes to testify on, for, or against House Bill 3133. We'll ask again, anyone present wishing to testify on, for, or against House Bill 3133. Still seeing and hearing none. Public testimony is closed. Bill is left pending at this time. The chair lays out House Bill 668 by Representative Bell and recognizes its sponsor, Senator Colcourse, to explain the measure.
Thank you, Mr. Chairman and members. Getting my steps in today, going back and forth. House Bill 668 by Representative Bell. Under the current law, members, an individual who successfully completes the extension process of applying for a Texas license to carry a handgun is issued that license for an initial period of 4 years. Renewed licenses are valid for 5 years. However, if a licensed handgun owner forgets to renew their license by the expiration date, they could lose their license and have to start the application process all over again. Starting the process again would involve an extensive list of requirements for a new applicant, including proficiency training, fingerprinting, and identifying identity documents, submissions, and all of which already is on file with DPS for the renewal process. House Bill 668 would add a one-year grace period after the expiration of an existing license to carry for a holder to go through the renewal process. The bill makes no changes to the existing renewal application process, but seeks to protect the holder from the burden of going through that entire process of fingerprinting, proficiency with a gun, etc. Finally, this one-year grace period is in line with those rules already adopted by DPS in administrative code, and this bill just simply codifies that policy. So a little 4-word, one-page bill codifying the administrative code that DPS already practices.
And thank you, Senator. Any questions for Senator Colhorst on House Bill 668? Well, thank you. We'll open public testimony on House Bill 668. Is there anyone wishing to testify on, for, or against House Bill 668? Public testimony is open. Anyone wishing to testify on, for, or against? We have a resource witness. I don't have any questions for them. Do you need the resource witness, Senator? Senator Schwartner? Okay.
We're pretty good.
Very well. So is there anyone wishing to testify on, for, or against House Bill 668? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. Thanks, Senator Colhorst. All right. Right on time. All right. Perfect timing. The chair lays out Senate Bill 3070, and recognizes its author, Senator Hall, to explain the measure.
Thank you, Mr. Chairman and members, and I will spare you. This layout will not be as long as my last two on this subject. I'm sure you all remember all of it. I'll just hit some of the highlights of it. And everyone should already understand the Lottery Commission's long list of wrongful and illegal acts. The Lottery Commission changed its administrative roles to help criminals rig the lottery. Most of these changes were made in direct contradiction to existing law. They directed contractors to send dozens of lottery machines to retailers without asking any questions. One of those retailers didn't even have a valid license to sell lottery tickets. This decision resulted in a guaranteed jackpot in 2023. The Commission allowed a business entity named Rook Texas to collect proceeds of the $95 million jackpot. The Commission lied to the Legislature at a hearing by saying they could not regulate couriers. Later, the Lottery Commission announced that they could regulate lottery couriers once it became politically convenient. Additionally, the Texas Lottery is a very regressive tax. And I've handed you a chart to show that what we're doing is we are funding the state on the backs of the poor with this regressive tax. And it's a good demonstration of the inverse relationship between personal income levies and participation in the lottery. Those of you who don't have the graph, what it shows is that the lower income areas are overwhelmingly supporting the lottery. The high income areas of the states barely play the lottery. So The money coming into the state from the lottery is coming from the lower income folks throughout the state. Education level and lottery participation are also inversely correlated, meaning less educated people are far more likely to play the lottery. So when we talk about the revenue raised by the Texas Lottery, we're talking about revenue raised to the detriment of those in our state who are the most vulnerable and least fortunate. But even though the Lottery Commission colludes with criminals to defraud Texas, and the lottery itself is a little more than a burden on most vulnerable people in the state, the Lottery Commission is also good at raising funds that benefit schools and veterans. These contributions amount to a little more than $2 billion in fiscal year 2023. So if there isn't enough of an appetite to get rid of the lottery outright, then this bill represents the next best thing. Moving oversight of the lottery operation to TDLR and dissolving the Lottery Commission. The bill includes a limited scope sunset review of the state lottery that must be concluded by August 31st, 2027. This will allow sunset staff to evaluate and recommend whether to continue the state lottery. Unless continued, the state lottery will be abolished on December 1st, 2027. This would not include the bingo program, which would not be subject to abolishment under this provision. In this version of the bill, retailers are prohibited from selling more than 100 lottery tickets to a player in a single transaction, and I plan to offer floor amendments to make a retail subject to a Class B misdemeanor for violating this provision. The introduced version of the bill also ensures that TDLR will enforce prohibitions on playing the lottery over the internet. Right now, the bill says that will result in a Class C misdemeanor. I have an amendment will raise that to a Class A misdemeanor. The bill also includes a provision that says no appointed member of the Texas Commission of Licensing and Regulation, TCLR, can serve if they have ever been convicted of a felony or any crime of moral turpitude. The bill creates a new lottery advisory committee to provide guidance to TCLR. It will be made up of members of the public, licensed sales agents, interest groups with differing views on how the lottery is operated, and entities that benefit from the lottery. The advisory committee members cannot be compensated for their participation, but can be reimbursed for reasonable expenses incurred during their service. I plan to offer another amendment to ensure that the Lottery Advisory Committee meetings are fully open to the public. TDLR's Financial Crimes Intelligence Center will also have the discretion to identify and respond to criminal activity related to the state lottery and charitable bingo. As for the dissolution of the Lottery Commission, the dissolution will occur on December 1st, 2025. The rules adopted by the Lottery Commission will remain in effect until they are amended or replaced by TCLR. All license or permits issued by the Lottery Commission remain in effect as if TDLR issued them. All contracts, leases, assets, and obligations of the Lottery Commission will be transferred to TDLR. The Lottery Commission's budget will also transfer to TDLR. As for the Lottery Commission employees, the introduced version of the bill includes a provision that says TDLR must first consider applicants who were employed by the Lottery Commission when hiring employees to manage the lottery department. I have some thoughts on that, and I don't think that the Lottery Commission's leadership should be considered for employment. Preferential consideration to employees who were not involved in the Lottery Commission's activities that got us into this mess are fine. Those other employees have done a fine job and are probably the best people to continue the lottery's day-to-day operations. I have other changes I plan to introduce as floor amendments. First I want to make will be some technical cleanups. Ticket purchases can only be made in persons at licensed retail stores. Retail stores must have a Lottery Commission approved age verification process at the point of sale. Tickets can only be purchased in retail store during normal business hours. All new rules and rule modifications must be in full compliance with Texas statutes. The amendment will remove the preference for current lottery employees, and in the Finance Committee meeting, Senator Bencourt talked about how the Lottery Commission would benefit from having commissioners with backgrounds in law enforcement, legal affairs, and finance, and assuming the new advisory board members also have previous experience with lottery operations. I think the new advisory committee will benefit from members with these backgrounds. The Second Amendment will clarify two penalties. A violation of Section 466.254 is a Class A misdemeanor. This section prohibits vendors, lottery operators, and officers of the Commission and their families from purchasing lottery tickets. And a violation of 466.255 is be a Class B misdemeanor. This is a new section that prohibits purchasing more than 100 tickets in a single transaction. Third, an amendment that promotes more transparency than the file version. The Lottery Division is prohibited from using email or document tracking software that automatically deletes without a prompt from the user. And all documentation, including emails, must be preserved for at least 18 months. And comprehensive minutes from all formal and informal meetings between Lottery Division personnel will be posted on the Lottery Division website for 10 years. This posting must include, as at a minimum, purposes of the meeting, minutes of the meeting, names of attendees and their business associations. The last amendment will add necessary rules. Ticket redemption can only be made by an actual person. The person must complete an IRS compliant form that is complete and independently verified by the Commission. There must be a hard limit of 5 lottery ticket printing machines at any single location, and the state auditor must conduct an annual comprehensive audit of all Lottery Division actions. Each audit must specifically identify any lottery actions or activities that differ from previous audits. And TDLR must prohibit extension of the current contract and issue a new RFP for a vendor on September 1, 2025. This section of the code it will be enacted immediately if we have a 2/3 vote. And the governor, lieutenant governor, attorney general, and speaker of the House are automatically TDLR approved inspectors of any lottery operator or retailer. With that, Mr. Chairman, I'd be happy to take any questions.
And thank you, Senator Hall. Members, any questions for Senator Hall on Senate Bill 3070? Well, thank you for all this. Well, my goodness, all your research and exposure and digging and coming up with solutions. Thank you, Senator Hall.
And I didn't bring it here. This bill will include the SB 28, which eliminated the couriers. It will be included in here, so the couriers will be gone with this.
Thank you, Senator Hall. If there are no questions, we'll open public testimony on Senate Bill 3070. Chair calls Rob Kohler. Rob is the only witness who is registered to testify on, for, or against Senate Bill 3070. This bill is in really good shape. And so if anyone else wishes to testify on, for, or against, please come down to the table and let us know. Mr. Kohler, welcome. Introduce yourself and go ahead.
Thank you, Senator. Here, my name is Rob Kohler, representing the Christian Life Commission of the Baptist General Convention of Texas in favor of the bill. We appreciate Senator Hall's support, Senator Hughes, all the senators, and especially Lieutenant Governor. Changing and removing anonymous ability to claim prizes is critically important. We would have never had the $95 million jackpot still if that was not in the language. That was changed in 2017. We believe that it was just part of a nationwide effort to allow multi-state games to be sold across state lines. So we operated 25 years without that language, never had this problem, and then that change to go back. The last one that I'd bring up is prohibit ticket purchases, selling tickets over $20. We got $100 scratch tickets and $50 scratch tickets right now. They've gone from the price of a candy bar to the most expensive things in the store. So with that, thank y'all, and appreciate everything.
Well, thank you for your testimony. Senators, any questions for Mr. Kohler? Thanks for being here.
Yes, sir.
Is there anyone else present wishing to testify on, for, or against Senate Bill 3070? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. Well, thanks to each member and your staff and our excellent committee staff and the people at the Senate that keep us going and set up and take down and keep the sound and everything else in the place clean and welcoming all of our guests, and for every witness on, for, or against, and to our folks observing tonight. We thank you. And with that, if there's no further business, Committee on State Affairs stands in recess up to the call of the chair. Good evening.